Jim, good evening to you on a Saturday night. No trouble with the weather driving over?
No, everything's fine.
Yeah, it kind of kept everybody off the roads a little bit. Everybody driving safe. All about injury. We've been doing this topic for a number of years. You can't go wrong with this one.
Well, you know, it's our bread and butter at Reason Media. It's what we do mostly. And so it's a great topic. It covers a lot of ground. And we've got a great guest tonight, all the way from Pascagoula. He's been here so often, he ought to be part of the show. But we bring you back so often because he's so good.
It is.
Matt Lott, from Pascagoula. My good
Matt,
friend.
great to see you, man. A little bit seriously about some of the misconceptions that are out there about a trial. You know, you see it on TV dramas and all the different law shows that are out there now on cable television. But there's still a lot of major misconceptions, aren't there, when something really goes to trial?
Yeah, there's a lot of hearings that go along before you even get to a jury trial, and there may be situations where you try to present your case to the jury and some evidence doesn't always go forward. One of those is insurance.
Right.
The jury doesn't always get to, really never gets to hear that there is insurance involved in most cases.
And that's generally,
that's incredible.
I've said it several times on the show, but the rules of evidence prohibit us as attorneys from ever revealing to you, if you sit in on a jury, that there's insurance involved. And almost every serious personal injury case or death case, there's insurance. They generally have the trial because the insurance company for the defendant whose person is being sued wants the insurance company to pay and have it go away. The person bringing the lawsuit obviously wants the claim to be paid to go away. Court often does too. You're there because an insurance company is refusing to pay, and insurance can never be mentioned. In fact, if it's mentioned by the attorneys in the presence of the jury, there'll be a mistrial declared. It has to start over. So it's one of the rules of evidence. I think it's archaic and it should be changed, but that's the status of the law. You'll never hear it. The jury will go the entire time and assume often that there's no insurance involved, when that's just almost never the case.
Of the week, and we got a good one tonight. This one came in over the email this week, and everybody's like, oh, we got to put this one on the show. Mike writes in, he said, my weekend of golf was cut short. I was hit by a cart. I was injured and went to the ER. The cart driver was drunk. Is he responsible, or is the golf course for letting him drink too much? Mike, very interesting question. We never had that one on the show before. Jim, what are your thoughts?
That's the first.
That's a first.
I've been to some golf courses.
We were talking about it. I'm surprised we haven't gotten this one before.
Well, you know, a couple things. We need a few more facts, but the general rule is an establishment that serves alcohol is only responsible for injuries that someone they're serving may cause if the person was visibly intoxicated and they continued to serve them. So that's the first question. Could the golf course itself be responsible? Maybe, depends on the facts, okay? And so the second question is, you know, when you drive a golf cart, like if you drive anything else or do anything else, you have a responsibility to act reasonably.
Sure.
Driving drunk and hurting someone, probably not reasonable. So probably a case there, whether there's insurance coverage, you know, as a separate question. But that's sort of the way you'd want to analyze that problem. And depending on the facts, you may, in fact, have a case.
Mr. Lott, what are your thoughts?
Right, it's very fact intensive because, you know, every golf course is a little bit different. You may have somebody that drives around and serves alcohol, and whether they saw that person was visibly drunk or not would be fact determinative. If they just brought beer or alcohol into the course from outside, that would be something totally separate.
Right. And that's a big factor. We all know there's golfers that kind of pre-game, if you will, a little bit.
We've talked a lot on this program about what to do if you're injured in an accident. Of course, you should immediately seek medical attention. It's also a good idea to take notes of everything you remember about the accident. But is there anything you shouldn't do? Absolutely. Don't downplay your injuries if you said you were fine at the scene. It may come back to haunt you if your injuries prove to be more serious. Don't make any kind of statement, even one to an insurance company or rep who tells you it's off the record, until you've consulted a lawyer. And never, ever attempt to negotiate with an insurance adjuster or sign any type of settlement without consulting a personal injury attorney. One wrong move at such a critical time, and you may never be able to get what you're entitled to from the party who was responsible for your injuries. That's your legal brief for tonight. I'm personal injury attorney Matthew Medier. Back to you.
Thank you, Matthew. Always.
People so much now post things on Facebook and social media, and one of the things you shouldn't do if you're injured or if you're communicating with an attorney about your injury, never ever post on your Facebook, you know, what your attorney's told you about the case or even the facts about your case. defendants now, it's so routine to basically search all of your social media sites.
Right.
And people routinely will get on there and post, their entire lives a lot of times on social media. But if you do it with regard to an accident and you have a case pending, you're probably going to see that and have some questions about it from the defense attorney at some point. So don't do that.
Okay, that's always.
I see it a lot now.
That's good advice. What can we help you with tonight?
Good evening, Gene.
Yes, good evening. I'd like to ask you, if you've been in an automobile accident and the person that hit you had no insurance,
Okay.
what happens as far as your uninsured motorist? How can you know that you're going to be covered for your uninsured motorist? I've received a letter that says either file the claim or you can file a lawsuit or settle the claim, and I'm just wondering, I need to have some surgery done, and how can I be assured that I'm going to get this paid for?
Right.
Since it's my own insurance, I'm more or less fighting.
Gene, great question. I hate to say it, we get this one every so often. Matthew, why don't we toss it over to you first here?
Yeah, it's very, very common to fight with your own insurance company. You think you've been paying these premiums all these years, and it's just going to, pay for itself, and
Right.
they're going to work with you. But it is very common to even have to sue your insurance company to try to get payment. Usually, if it's a clear negligence case for the other guy, they should step in pretty quick and take care of that. But they don't always do that.
Right.
Yeah.
And then, so what do you think? Do you think she got a letter from her insurance company then, Jim?
Here's sort of the steps you probably need to take, Gene. So first, if it's a serious injury, and it sounds like you're talking about a surgery, it is, you need to talk to an attorney and get them to assist you, or at least sit down and meet with attorneys. We do this kind of thing, and attorneys who practice in this area will talk to you for free, okay? And so you can sit down, see what your rights are, they can look at your coverage and tell you what you need to do. But typically, these are the steps. You notify your insurance company of the accident, put them on written notice of it. They'll then take a look at it. They may investigate the claim, and then they step into the insurance of what the person who hit you should have had. So it's adversarial at that point. It's in your interest to have them pay your claim. Insurance companies, guess what? They make money by collecting premiums and not paying claims. And so don't think because you've had them for all these years and paid the premiums that it's not adversarial. It is. They're basically stepping into the shoes of the defendant's insurance. So at that point in time, you talk to an attorney, you can make a demand for what you think your claim is worth. They'll either settle the claim and pay you, or if not, then you have to file a lawsuit against them, just as you would against the defendant, to recover that money.
That uninsured motorist, or underinsured. That's another way of saying it too, because there are a lot of Matthew. I don't know if you've run into this, but there'll be people who have insurance, but it just doesn't cover anything, does it?
That's right, and you have those policies in place to go over and above what somebody else may have.
That's right. And look, it's the best coverage out there. We try to say this in every one of these shows.
Yes.
It's one of the biggest problems you see in personal injury cases. In this state in particular, we have so many uninsured drivers, and even those that have insurance generally have a minimal policy, $25, $50, something like that, meaning $25,000 per person, $50,000 total of what they have to pay. A serious injury with a surgery, you will go through that in a few days.
Right.
And so it's just not enough coverage. But you can ask and demand that your own insurance company provide you the opportunity to purchase underinsured coverage, so that you basically add that on top of the coverage that the defendants would have had to cover your injuries in the event they exceed the insurance that's available from the defendant. Very, very important coverage. Everybody should look at it immediately on Monday. Take out your card, look at it. If you don't have it, call your insurance agent.
What can we help you with?
Hey there, how y'all doing?
Hey.
Basically, I got injured on the job a little over a year ago.
Okay.
And had been getting a check through the insurance company pretty regular. I mean, they cut it off one time before, but it started back pretty quick. And I had to switch lawyers, and it's been cut off again for about a month now.
Okay.
And I just kind of get to the point where I'm about to lose my house and everything, and I didn't know if it's really worth it to keep fighting them or waiting around, you know what I'm saying? Because I don't even have any other income and don't know really what to do if it's...
Lauren, it's obviously you're a bit of a spot here for sure, guys. What do y'all want to say? There's a lot here that I know y'all need some more information on. You want to take a first shot at this one, Matthew?
Yeah, it's very common in workers' comp to have checks get cut off.
Okay.
They could make it easy and do it direct deposit, but they insist on sending it through the mail, so it'll intentionally get lost, I think, sometimes. So it is very common for this to occur. You just got to stay on top of your attorney.
I see.
Make sure that they're filing whatever motions. You can even get attorney's fees in some cases if the judge wants to give them for intentionally doing that. If she's really owed the money.
So this sounds very common to you. Yeah, right there.
It's unfortunate. I mean, it's really unfortunate. They are supposed to pay those checks regularly. Period. And they just don't.
Does not happen.
And Matt does a really good job and does a lot of workers' compensation claims. And of course, his advice is spot on. But typically they're going to have to pay you until you reach a point of what's called maximum medical improvement, and that means essentially when your doctor says you're as good as you're going to get. And then, but if you've got an attorney, he should know the answer to all this. And then at that point, they may attempt to cut you off or have a lump sum settlement. But otherwise, you should be receiving those checks regularly unless you've reached maximum medical improvement. But if you've got an attorney, that's what you're hiring for. I would call them Monday morning and say,
Sure.
What's going on? What's going on with my check?
Lauren, I hope that helps a little bit. What can we help you with?
Hey, I have a question.
Hi,
Yes,
John.
sir.
I had an accident in a pool in my neighborhood, and I was wondering if my homeowners could be liable for my injuries.
Is it like a neighborhood pool there, John? And like y'all all kind of pay memberships into it?
Yes, sir.
I got you. I remember those. I haven't seen one of those in a while.
Like a community pool?
Yeah, like a community pool there. And John's pretty serious injury or noteworthy?
It was.
Okay. Let's turn it over to our panelists, John, and let's see what they have to say. Boys, Matthew?
I think it depends on who's the owner of the pool. I think that's what you were getting at.
Yes.
And so if it's a community-owned, like a
Homeowners Association or something.
That's what I think it is, yes.
Right.
then I don't think you'd be personally liable. I think the homeowners association would probably be a separate entity unto itself, and it probably has some insurance and that sort of thing that covers that pool, I would think.
That's probably right, and I agree. And John, so it's a little more facts that we need. So the first thing is who owns it, and then whoever owns it probably has an insurance policy, and that insurance policy is one that you possibly could recover from. Now, just because you're hurt on someone's property or in their pool doesn't necessarily mean that they necessarily owe any money on a claim. It's going to depend on the facts of what caused you to be hurt. Did a ladder break? Was it an unreasonably slippery surface?
Right.
It would depend on the facts that caused you to be injured as to whether or not there's potential liability.
Well, and Jim, you've talked about this several times on the show about slip and falls, and that just because it's a slip and fall doesn't mean that it's a lawsuit. And I think we've always been very honest on the show that there are just accidents out there.
Sure, no, it happens, and slip and falls, contrary to popular belief on business premises and that sort of thing, are quite often are the toughest type of cases to prove, because you have to prove typically that an owner had actual constructive knowledge of a defective condition and had an opportunity to fix it and didn't. So,
Matthew, if John wants to move forward with this one, is this something that he can do on his own to start off with, or does he need some professional help on this one?
He definitely needs some professional help. There's so many different liability issues and just kind of things that you can get into a jam if somebody was going to
call back later. We got an Ask Us Anything show.
Good luck, John.
In a couple of weeks, but we hope it all works out for you. And that is our last call for the evening. Thank you for all the great calls tonight. Wide variety of questions. We really do